Hi, I'm Emily and I am here with Maya Murphy's attorney, H. Daniel Murphy. Attorney Murphy practices at Maya Murphy's law offices in both New York and Connecticut. My question today for Attorney Murphy is, can a Connecticut divorce judgment or divorce agreement ever be modified?
So first off, a divorce judgment and a divorce agreement or a separation agreement are really the same thing. They both become an order of the court once they're granted and adopted by the order of the court. So that is whether you go to a trial and have a judgment or whether you reach an agreement and have a judge sign off on the agreement. Either way, you're dealing with a judgment of the court. And the short answer is that many things in a Connecticut divorce judgment can be modified unless you specifically agree otherwise or the order specifically says that. So property distribution, first off, that is a division of property. So a house, bank accounts, retirement assets, vehicles, investment properties, or a business. Those are items that cannot be modified. Once property is divided among the spouses in a divorce, you cannot go back and deal with that one-time transfer in any other way. It can't be revisited once it's final. So a good example of that where someone might want to modify a property division sometime after the divorce judgment would be in the example of selling a house. So a house is agreed to be sold or ordered to be sold at some point in the future, and let's say the property is determined to be split equally by the parties. Even though that property transfer happens, maybe a year, maybe 2 years, maybe several years after judgment, it cannot be modified in the sense that it's a property division which was already decided at the judgment, so you can't go back and change. However, there are other components of a divorce judgment that are ordinarily modifiable if certain criteria are met, and that is, very generally speaking, if there's a substantial change from the time of the original judgment to the time that someone's requesting a modification. Child custody, physical and legal custody of minor children is generally always modifiable, as the court has a specific duty to ensure that the best interests of the children are met whatever the circumstances are at that point in time. Child support also is generally always modifiable until the age of majority, and also the items associated with child support, such as extracurricular expenses or insurance coverage for the children. Whether alimony is modifiable or not is a very tricky question, actually, and greatly depends on the circumstances and the way that the judgment was worded, either by the court or in the agreement. As a general rule, alimony can be modifiable unless it expressly states that it is non-modifiable. So sometimes the length of time is modifiable and sometimes it's not. That means the time over which alimony is paid. Other times the amount of alimony or the percentage of someone's income that's awarded in alimony or some other component may be modified, but this is a whole area of discussion that really should be had with a lawyer specializing in family law. So to recap, property division is generally something that cannot be changed once property is awarded or split in a divorce. Child custody and child support generally are modifiable at any point in time as long as there are substantial changes that took place between the time of the judgment and the time that the request is made. And alimony might be something that can be changed, but in all cases, you should consult with a family law attorney about the facts and circumstances particular to your case.